is a big disaster to that family. And on behalf of his defense team, we also pass our condolences to the bereaved family, and may God give them grace as they deal with this sudden death. That's all, Your Honor.
Okay. Prosecutor, do you have something to say in response to what?
Yes.
Petitioners will make?
May you please, Your Honor, my name is Opundo.
Yeah.
Your Honor, so we are both the applicant and the respondent at the same time, so I'll take it globally in my response.
You are the you appear for the state?
Yes.
IPOA?
Yes.
Okay.
For the state.
Okay. Proceed.
I'm a prosecutor.
Okay.
Your Honor, we humbly submit that the evidence which has been tabled before you in the form of a affidavit clearly lays bare the reasons as to why the respondent should be detained for the period that has been requested. The circumstances leading to the investigation by IPOA is not in dispute. And this has been categorically stated in the affidavit. There is no dispute that life was lost. There is no dispute that the deceased died in Aphrodisia at Central Police Station, to be specific. And this was confirmed by the medical report which has been attached to the affidavit. And the OB extracts which have been attached. Which clearly demonstrate that the deceased was removed from the police cell, taken to Bangapi Hospital, where he was proved to be dead. There is no intervening incident. There is nothing which intervened which could say that the deceased did not die out of the cell. That is clearly demonstrated. It has also been demonstrated in the affidavit that the respondent is the one who was manned the sentry at the time. There was no any other person. That has not even been disputed. And the key reasons, which are the key grounds why this application has been made, is that there is fear of interference with witnesses. And the reasons have been given in the affidavit, which clearly demonstrate that this officer, the respondent, is likely to interfere with witnesses whose statements are necessary and who are police officers. Your Honor, it's our humble submission that when it comes to the issue of rank, that's not what counts when it comes to interference with witnesses. Interference can take any form, any shape. You don't have to have influence or bear any influence. Your Honor, it has also been submitted before you. It has also been laid bare in the affidavit that the nature of the investigations are complex. And, Your Honor, this court, and it has been decided in several cases, when the courts can consider granting such application. And this, I'll enumerate them. We'll give authorities, I'll give the citation. One is the serious nature of the offense, which is under investigation. The second ground is early and sensitive stage of investigations. The third issue is the forensic and surveillance-based complexity of the case. And finally, risk of interference with ongoing inquiry. The facts which have been imposed in the affidavit clearly demonstrate the four grounds which I've stated. Your Honor, it has been submitted that the arrest of the respondent was a knee-jerk reaction. We submit it was not. It has been established as to when investigation in this matter began by IPOL. It did not begin yesterday. It did not begin with the arrest of the respondent. Your Honor, at this stage, with Article 49 of the Constitution, and not Article 50. What Article 49 expects of the applicant in such a case is just to lay bare before the court the justification for continued detention of a suspect. We are not talking about the rights of an accused person who has already been arraigned before the court, so as to apply the principles which are contained in the bail and bond, the guidelines which have been given. You know, there are compelling reasons. Have the respondent changed to avoid interference with the investigation. Indeed, it is demonstrated in the affidavit that there was an attempt from the beginning, when it was realized that the theory of the suicide failed and it was established that the deceased was killed in a police, there was an attempt at interference or derailing the investigation from the beginning. And this has been demonstrated with attempts to destroy the data in the CCTV. That is demonstrated, and it's not immediate. A person who from the beginning wants to destroy the evidence, that is a person who will go all the way to interfere with any kind of incriminating evidence which may be unearthed by the investigation. And this is not just a mere preemption. There's all the likelihood. It has been stated that there are other suspects who are, include even police officers, who are likely to be arrested. They are out there. There are people who are known to the respondent. It has been decided in the case which we cite that where a suspect is likely to be out and communicate with witnesses and even other suspects who are still on the run, he should be denied, he should be detained when investigations are ongoing. The investigation in this matter is still at very early stage. And it has been demonstrated how sensitive this matter is. Your Honor, we submit that there has been an attempt. It has been demonstrated that the investigating officers have been finding it difficult to retrieve information from the police officers. Requiring more reason why the suspect who is in custody should remain in custody for a few days, which have been requested. Your Honor, I want to respond to the authority which you were given. This is miscellaneous criminal application number 26 of 2018. This one now, Betty Gemtai, female applicant, versus public. At the onset, Your Honor, I wish to submit that this was an application dealing with the extension of time after an applicant has been detained. It does not apply to this instant case. Your Honor, we submit that there are justifiable reasons for continued detention of the respondent before the court. Article 24 of the Constitution allows for limitation of freedom. Regard only need to be given to the importance of that limitation. The importance of the limitation which we are seeking is to enable investigation to be completed without interference. It would be total injustice Travis, just if investigation were interfered with, at the end of the day, there are no witnesses, there's no tangible evidence to be presented before the court, because a suspect interfered with the investigation. It will be a disservice, in fact, a dishonorable thing to the family who was lost. It goes even a long way in protecting victims of crime. Which this court has a duty to do. Your Honor, we finally submit that the investigation here has been established to involve issues of forensic and surveillance. And part of it has been demonstrated in the affidavit that we take a process of trying to retrieve data which has been attempted to interfere. And it has been stated by the investigating officer on oath that this is something beyond him. It's done by an expert outside within his control. He may not have control over that. And the days which have been sought, Your Honor, are reasonable in the circumstances. We are not saying that the applicant, the respondent, will not be given a fair hearing. Once the COVID investigation has completed its charge, will have his fair hearing, have his day in court without the rights of an accused person. We are just protecting the evidence to be tendered. Then on the authority which you have given on the issue of calculation of this, then I will submit that there is no mischief in the application which you have made. In any case, that does not go to the root of the application, even if you were to apply the rule of computation of this. These are mere procedural issues and does not touch on the tangible aspect of the importance of carrying out investigation and requiring this. "21 working days requested." It's not a mystery. It's an estimation in the sight of an investigating officer. And this, to the investigating officer, could be just a matter of nomenclature. He could maybe, to him, he would have asked for 30 days. But it's working, it's granted, to be honest. We urge you to allow our application for detention for 21 days and reject the application for bond at this time, as we jeopardize the investigation.
All right. Anybody else again in the prosecution side?
If I may.
Yes.
My name is Timothy from I4. My Lord, let me first say we agree entirely with the submissions made by the learned counsel.
Point of objection. I don't know under which provision an investigator will address you, because the investigators in this matter are equal. The officer who deponed the affidavit has given his side of the story. IPOA cannot submit. It is a preserve of the DPP. IPOA is a witness that we have cross-examined. And therefore, if IPOA has anything to say, let it hand over that to the DPP.
Okay.
The DPP should not cede ground to this crucial matter. IPOA cannot prosecute, it can only investigate. Article 157 mandates the DPP to be the mouthpiece of IPOA.
Okay.
So, Your Honor, we object to IPOA being allowed to address the court.
This one I need a response from Nora. You have given up to your driving
No,
seat
we haven't.
to.
We haven't. I thought our submissions were given by Mr. Ofunda. Yes, but I think I'd be honest. I do not know what the officer from my call wanted to submit on.
No, what we're saying is, if they are investigators, then they should also
Yes,
come through you.
that is clear in Article 157.
Yes. Mr. Kinoti,
Your Honor, if I may.
I'm not recording down meanwhile. I was just saying, if you have something, you should have also passed over to the DPP or stop. What's your take?
That is fine, Your Honor, and indeed we are working closely with the DPP. But, Your Honor, for purposes of record in the law, the participation of IPOA in bail proceedings has been determined by the High Court. That IPOA can participate and address the court in the case of Republic versus Frederick Oleleliman, where IPOA was granted audience by the High Court in a decision, Your Honor, of the High Court in this case. We also didn't submit your decisions. So, Your Honor, the participation of IPOA in addressing the court is a matter that the High Court has settled. Yes, Your Honor. And so, Your Honor, there is no prejudice whatsoever on IPOA submitting on this issue. And in fact, Your Honor, as an officer of the court, all I wanted to do was bring to the court attention that decision that I've just mentioned of Republic versus Frederick Oleleliman, which is at complete at one with current case that Your Honor is dealing with. And having brought it to your attention, Your Honor, that decision is available at EKLR. When you retire, Your Honor, I would urge you to have a look at that decision.
So, I hear you to say you are investigating the murder issue, is it not? So basically, you are for the victim.
Yes, Your
Is
Honor.
that so?
Yes, Your Honor.
What about the Supreme Court case of Redrick Waswa?
Your Honor, before you go there,
Just as a minute. Yeah, because it gives you some attitude, to what extent that the counsel for the victim should address the court. Is it not?
It does, Your Honor. It does.
To what extent the Redrick Waswa case, the Supreme Court?
Yes, Your Honor, it does. And
I believe the Supreme Court case finds the courts below.
It does, Your Honor.
So I was thinking that you can also look at it and see.
you know what I was raising?
Yes.
IPOA does not have jurisdiction under the Victims Act. They are investigators, like EACC, like the DCI, like KRA. They do not represent the victim, and therefore they cannot pretend to be investigators and represent watching brief. That role is very clear, and that notion should be put to settle. The DPP is the only one under 157 with that constitutional mandate. Anybody else, if they are civil society groups representing the family, they have a right. Waswa's case has given them the right and the scope to participate. But an investigator talks through the DPP. He cannot pretend to be a prosecutor. That's all that we are saying. Their roles and the mandate is very clear. Section 3 of IPOA is very clear, very distinct from Article 157. Let us defend the constitutionality of this country.
Okay, I hear you, Mr. Mari. That's enough. So, just a minute, Mr. Kinoti, are you okay that you can pass your submissions to Mr. Opondo?
We will pass our submissions to Mr. Opondo. We have no objection to passing our submissions to Mr. Opondo.
Okay.
But Your Honor, for purposes of record, the position of the law enunciated by Learned Counsel Mr. Omar is not correct, Your Honor, for purposes of record.
Okay.
Our position, Your Honor, our position remains
Yes.
that as decided by the court in that case, just mentioned, IPOA can participate in proceedings before the court. But, Your Honor, we have no objection of passing our whatever we
because
need
if
to.
you are for the victim,
If the court issues
you are
us-
allowed to participate. That one is allowed.
I think
Yes,
also
Mr.
what is
Nyanzi?
happening is that my colleague is misreading that decision. Because, Your Honor, if you look at that decision, and I believe that is the position, is that IPOA at that time was watching brief.
Yes.
Okay.
In this case, even if you look at the heading of this proceedings,
Yeah, the
it is
investigators.
Republic to the IPOA.
Okay.
So your mouthpiece is the DPP.
I think as the DPP, let's put that matter to rest.
Yes, kindly.
We will advise accordingly.
Yes.
We will respond to the issues raised. Yes, on behalf of IPOA.
I think that is settled.
That's it.
Mr. Kinoti?
Yes, Your Honor.
It is settled.
We are okay proceeding with
Okay.
through the DPP.
All
But the
right.
position of the law, Your Honor. is that
Mr.
we have
Opondo,
stated.
you had said something?
Yes, Your Honor. I said I will give the court recitation of the policies. I concluded before doing that.
So what is it? Number one is?
Number one is Republic versus Geoffrey Mutuku and 4 others. This 2015 EKR.
2015.
Yes.
Okay.
And we also have Republic versus Jackson Munene Ndugu. 2020 EKLR. We also have Republic versus Paul Ndungu Waweru. 2016 EKLR. We also have High Court at Nairobi, criminal case number 57 of 2016. That is Republic versus Frederick Lehman. And 4 others.
Okay.
That's all.
Right. So are we done? Prosecution side?
Yes, ma'am.
All right. So, Counsel, I think this is a matter which has a lot of anxiety, and you have really submitted a lot. I can see you have been recording 20 pages of typing, so it means it's quite a lot. I need time to write this ruling. Yeah, so we shall take a date for the ruling, whether he's going to be in custody or released. Are we together?
We are together.
So we can have it on the 20th of this month for ruling.
That's convenient, Your Honor.
IPOA, where do you want him to be detained in the meantime? Capital here. All right, we come back on that day for ruling, and I think he'll be in custody at Capitol Hill Police Station until then.
Your Honor, finally,
Yes.
my client is still available for investigation.
Mm.
The days let the police not wait until we come that they say they are, then anybody stop them from investigating. Our client is available to be investigated. No.
All right, then we come back on 20th for ruling.
Much obliged.
All right. Can we have another file also? Yes.
Sasa unapiga sasa fanya nini? It's very slippery. Eh?